everybody, I put up a video that was called The Myth of the Cestui Trust, right? And what I was trying to do is explain to people that I'm not saying there's no Cestui Trust created, all right? But everybody took it as that. What I was saying is there isn't a Cestui Trust set up first. It's a bailment, all under the law of agency. It's a bailment first. Then it becomes, then they create trusts with an S, off of that bailment. The Social Security trust being the biggest one that ties them all together. So any trust with a beneficiary is a cestui. You could call any trust a cestui as long as there's a beneficiary. The beneficiary is the cestui.
Right, exactly. A lot of people use those terms incorrectly, and they want to call the cestui trust a trust, whereas cestui really means the one who trusts who's receiving the benefit.
Right. Exactly. So there's a lot of those created after, in my opinion. I mean, we don't see them, but there's probably more than one, I'm sure, created after the bailment takes place. Because once you perform a bailment and you give property over to a warehouseman, okay, that warehouseman can now get loans based off of the property he has bailed. Okay. And to do that, he has to create a trust because the property isn't his.
Right.
See, that's how this whole thing is really working, you know? And I started seeing this and I'm like, oh, that's why I was able to discharge my criminal case with my birth certificate, because it was a negotiable instrument. It's just a warehouse receipt. So I negotiated that back to the warehouseman and said, hey, guess what? You know, I flipped the roles here. Now I'm going to order you to discharge this, you know, based off this commodity that you're storing here, you know. And I didn't say it in those words, but in essence, that's what was actually happening. So creating a trust is very important to take control of your entity, you know, because what people are doing, I noticed, is a lot of people, you know, when you're doing UCC and you're doing all this stuff, all you're doing is reaffirming that you are administrating that property. You don't have a right to,
right?
You know, so the best way to do it is to take that property and give it to another entity, which is a trust. That way, you're not owning or administrating anything, and you don't have a right to. So if anybody tries to force you to do that, you go, oh, wait a minute, you're forcing me to break the law.
Well, let me if I can interject real quick. When you're saying that the trust that you're creating is going to take control of this entity, you're doing this through administrative closeout process, though, correct?
Well, in terms, when you say doing this, you mean actually getting the entity into the trust?
Correct.
Yes. What you're doing, the administrative process, is simply the commercial side of making sure there's a clear chain of title. Because you can't move any property unless you have some sort of security agreement showing that you have clear title, that no one stepped up and claimed title. So the administrative process is done on the commercial public side, and then the common law notice in the newspaper and the legal notice is taking care of the common law public side. See, so I did both of those but the declaration of status is absolutely key. You have to do that. Without that declaration of status, you have no treaty to come under. You know, now there are groups out there I know that are doing, like the Government for the United States of America or something. They've been around for a while and they're doing their thing, and that's all well and good. I'm not going to, you know, say it's wrong or it's right or it's anything really. It's just not my bag. You know what I mean? So there has to be treaties in place, and I'm sure they know that as well. I'm sure they're doing declarations for people and all that. The declaration is key. It has to be done, man, and that's where you have to, you know, accept and acknowledge that entity, that certificate, that warehouse receipt, you know, or, well, the bill of lading, really. Because you're just clearing title. Once you clear the title, then you have the right to put it into a trust. But you can't grant it into a trust. I shouldn't say you can't. My opinion, you shouldn't be a grantor with it. You should be a creator, okay? Because you're going to exchange it. And a grantor grants property to a trust and retains equitable title. With an exchange from a creator or a trustor, and you're exchanging it into the trust, you're not retaining any title at all.
you're saying when you're a grantor of a grantor trust, let me back up. A grantor trust, is that different than if I was to be the grantor of property into trust?
No, that is exactly what it is. So if you're granting property into trust, you're retaining equitable title and you're giving legal title to the trustees. You're splitting the title.
Right. Well, which I guess for those who don't, who are new to this, maybe we should go back and define what a trust actually is. What you basically explained right there is you're splitting the title between equitable and legal property. You're transferring it from ownership of one person into the ownership of the trustee for the benefit of a third party. That third party, you're saying, could be the original grantor. Are you saying that's absolute? That in a grantor trust, that equitable title absolutely is going to be retained by the grantor, or is that just a possibility?
Yes, depending on the trust structure, right? That's and it's revocable that way. But irrevocable means you can't retain title to, and you can't retain equitable title. You're giving both titles up. That's what you want to do, because you want to have no ownership whatsoever. So that's where the common law trust comes in. And I've seen a lot of purported common law trusts that people bring to me, go, hey, can you read this? Check this out. What do you think? And a lot of them are very flawed, man, very flawed, just on the fundamentals. So you got to be careful. But that's why the common law trust is so important, which is also called the Massachusetts Trust, the Pure Trust. There's a bunch of different names, but it's the same structure.
Right.
Contract trust, basically.
Right.
Would the statuses be custom?
Hold on, Jay. You want to take a question real quick? I think we got somebody.
Oh, yeah. Go ahead. Yeah.
All right, go ahead, David.
Wouldn't the contrast, I'm sorry for interrupting, wouldn't the contrast be custodial versus allodial? Allodial versus custodial?
Yes, custodial is the government, right? They're the warehouseman. So custodial is the warehouseman. Allodial is you. Right. But you don't even want allodial title to that thing. You want the trust to have that title. So how I did this on my own, the way that I studied and brought my own thing together was I need to take the title first, right? Because somebody's got to claim that title. So my process and my thinking was clearing the title, making sure no one had a claim to it, giving plenty of notice, creating the security agreement that everybody agrees we're on the same page, which was the administrative process. Then and off of that administrative process, then you put your notice of lien in their system, which is a UCC1, very simple. Doesn't need to be 8 pages like I see some people putting in. I think that's kind of ridiculous, in my opinion. But you do a simple UCC1. It's got some pertinent parts in it. And then you also do a newspaper notice in the county where the trustee last was, or the last title holder, the parents or the carrier, so to speak, right? Because
the birth state?
Yeah, the birth state, the birth county, you got to know, where, or not you got to know, but you got to notify where the last known holder was, right? The carrier, which was your mother and your parents. So you've got to put the notice in their jurisdiction, in their county. So I put it in a newspaper in that county, and it's a common law notice. So I took care of that side. So now I had remember, in a bailment agreement, the bailee, which is them, retains custody. So they are custody, do have custodial, let's say they have custodial duties. But in a bailment agreement, the bailor always retains title. See, we always have title. We think we don't. So all we're making sure is, hey, we're all in agreement that I have title, right? Yes. Okay. Now I've got documented evidence that we're all in agreement that I've got title. So now that that's clear, I, as the bailor, am going to give this title over to the trust. Okay. So yes, I become the one fully vested in the title. Then I give that over to the trust, because as a man, a creation of the divine, I can't own anything, especially something that has a mark of the beast attached to it. So that has to go into a trust, and it goes into the trust for me to do the will of God.
Sure.
Okay, so the trust provides, it's a nonprofit to provide me to do the will of God, because I can't do that with a number on my back. You know,
cool.
That became my, now again, I don't want to, you know, make anybody believe this is the latest and greatest, you know, patriot thing going out there. This is just what I did, and I've seen amazing results from it, and it's how I continue to operate.
What do you call it? What do you call it? What's the name of your trust? What's the form of it?
It's a common law trust. It's just a business trust, private business trust. Okay. Common law contract trust. Yep.
Gotcha.
Because to me, it made sense. Well, wait a minute. You know, I see all these people doing all these ecclesiastic trusts, this, that, and the other. And I'm thinking, well, wait a minute. This entity is designed to do business. It belongs in a private business trust, which is a common law trust. It's what it's set up for.
Sure.
You know, and you can add the ecclesiastic element to it, which is what I did. I put in there that the purpose of this trust is because I, as a man, cannot own anything, just what I was saying a minute ago. Sure. That's right. The purpose. So, you know, now it's really solid, because who can go against what's God's? Not even the government. They know that, because this is all set up on this shit, you know?
No, you're absolutely right. You're pulling in two different elements that are very protected status, which is your spiritual religious side to life, which we have already seen. You know, I mean, the First Amendment, you know, I mean, these things are supposed to protect people's religious rights. You're supposed to have separation of church and state. And plus you have the contract law and the common law. You have all these things that are foundational to the creation of government itself. Mm-hmm. That if you're drawing from these elements, now you're able to reach in at the same levels that they were creating government at. Right?
Yes, that's exactly it. Yeah. Yep.
And I'm right there.
And so much so that, you know, people have reached out to me from some pretty high places, you know, recently, and they want to talk. And, you know, I'm a little bit, you know, not nervous, but I'm like, you know, I'm just going to keep my mouth shut and let them talk, because I'm not giving you shit, man. I'm not giving up the, you know, not what's going to keep people free, because these high level people, I don't know who the hell they are, but they're high level, and I don't know what they're getting my information for. All I know is that they've got information that I need. So the next level is coming for me.
Do you feel safe, protected?
Always. Because if I start feeling like I'm not, then I'm not, you know. Right. So I just roll with it. Like CPS just came after me from an altercation that my son was involved in. He's 11, and our neighbor left him and her son. She got drunk and jumped in the car, and my son was like, I'm not driving with you. So she left my son and her son at a pool in some neighborhood like 10 miles away. So the cops came. CPS goes after her, right? And then the cops come to me, and now they want me to rat her out. So CPS starts calling me. I'm like, I'm not dealing with you people. I don't have to give you any information.
Right.
So a week of them trying to contact me not answering the phone, they started leaving threatening messages. You know, we're coming after you. So I said, okay, let's get on the phone. So the interesting thing, what I'm getting to, is I haven't heard from them since. And in Florida, CPS is really freaking bad. The day they call you, they're showing up at your house either that day or the next day, you know, and I haven't heard a word, you know. Not only that, but I want to bring this back to the protection thing. If I do hear a word, I really don't give a fuck, because I'm protect. Like, you want to start this? Let me pull out all the records of who owns what property here, because my son is my property, you know, and I've got all the records to prove it, and I got all the records showing you guys failed to respond. And when I was in federal court testifying for my buddy, they tried to get me to testify against him, but I worked my testimony in such a way that I made them believe I was testifying against him, but I actually testified for him. And when he was cross-examining me, because he didn't want to get an attorney, you know, one of the things that I picked up on was they asked me, you know, well, this man created these notices and you were in his group, and what did you do with these notices? I said, I notified people. You know, it's my understanding that if I notify you and you don't respond, you've agreed. And they go, and then the prosecution starts going, oh shit, like, duh, we shouldn't ask that question. They go, well, and how many of these notices did you send out? I said 225 of them.
Oh, shit.
So if you guys failed to respond, It's my understanding that it's no longer my problem because nobody said it was illegal. And the judge, they kept trying to go, objection, objection. And the judge was like, I don't think so. He kept saying, I want to hear this man's understanding. Because I had him. I mean,
well, they go off the same premise. They go off the same premise. They notice you,
exactly,
and they tell you fail to respond.
Yep.
Does your reputation precede you? Do they know who you are, man?
Yes, they do. Yes.
It sounds like you can back them up on the hills pretty easy. So they must.
Well, yeah, I did some shit in the Detroit bankruptcy you can find online, and that put me on the fucking world stage map pretty much. And Obama was pissed, and the Pope was pissed, and they were all freaking pissed. So they came after me, and they arrested me in 2013, which is why I wound up in federal court the following year. And but they didn't arrest me for what I did in Detroit. They trumped up a story out of another states, so it wouldn't lend credence to what I was doing. Because if they came after me for what I did in Detroit, that would just lend credence to all of our community. They'd be like, oh yeah, obviously knows what he's doing, But that was the reason, and I could tie all that in another story. But so the long and short of it is, after I finally got out, I was never charged and I never had a hearing. Okay, but when I got out, they had me on bond for 2 years. Now, the deal was if I testified against my buddy and I did all these polygraph tests and these interrogations, that they would dismiss my case. Okay, well, 2 years went by and it still wasn't dismissed. And I never had a hearing, and I was still on bond, and I still had to call bond company every week to let them know I didn't flee the country. So I was pissed. I'm like, they made me hire an attorney, which I did because I wanted to get home to my son after being in jail for 5 months fighting extradition, not because I was charged, because I was fighting extradition in Maryland. Spent 5 months there. They sent me to South Carolina, spent 2 months on an ankle bracelet. I was like, fuck this, give me an attorney. I'm getting the hell out of here. I don't care. I got to get home to my son. I'm a single father. He's with me full time. That boy needs me. I got to get home. So I got the attorney. He got me out based on this premise that they would help me out with this, shit. So anyway, 2 years went by. I got pissed off, man. I was like, why is this case not dismissed? Well, I started getting back in the game, studying more about trust, studying more and more and more. And when I put the process together that I just laid out for you guys, I issued a birth certificate as a bill of exchange on the back to a probate judge. I didn't file anything. No, I never file with any court. I don't even care if it's probate. I'm not filing shit. I'm noticing you. You've got a problem because the owners of the trust and I, as the executor, have exchanged that property into the trust. And now the trust is going to issue you a bill of exchange because it has insurance of 21 silver dollars for you to pay any debts of the debtor, to set off any debts of the debtor. And 2 days later, my case was dismissed.
Really?
In another state. Wow. See? So it took me, and not only was my case dismissed, but so was my co-defendant's case. Okay, and the reason my co-defendant's case was dismissed, and he didn't even know it because he was in jail at the time, they gave him 3 years, was because when you open a court case, and you probably know this, a lot of you probably know this, when you open a court case, it's opening an account. That's it. So any co-defendants you have are sub-accounts of the account. So if you discharge the main account, you're going to discharge all the sub-accounts. That's just banking, So what I did was I discharged the main account. So it wiped his out too, and they released him. They dismissed his case. And the judge on the case was the attorney general. So that tells you right there. The attorney, this was in South Carolina, the attorney general for South Carolina. So let's think about that. What is an attorney? An attorney is someone who attorneys for someone who transfers the rights from the tenant to the landlord.
Right.
Well, a tenant-landlord relationship is also a warehouse relationship, believe it or not. Okay, they consider that a warehousing relationship.
Oh, great.
Right. So here you have the warehouseman who transfers the rights from the tenant to the landlord that discharge or dismiss the case. Makes sense to me.
You're absolutely right. A torment is transferring rights and interest, and that's all they're doing.
Yep, exactly. So all the pieces fit, and when I saw that, I was like, oh, holy shit, all my theory, because everything's legal theory until you put it into play, worked. And I was like, damn, okay, because I took the elements that I saw working over the years that I've been studying this stuff, and I was like, what is working repeatedly? And I put all those elements together, and that's how I came up with the way that I did everything and how I operate now, you know. So now,
when you filed that birth certificate, had you already done your trust and all those things at that point?
Yep. Now, I didn't file it. I noticed here's the reason I did this. So
I don't mean filed it in that court case, the trust. I mean, like, done all your notices, public notices, and all that stuff with your trust,
and all my recordings at Lamar County, all that stuff. Yeah. So what I did was in Maryland. Now, I don't know about any other states, but I researched probate courts, because probate's where everything's happening, right? That's where estate and family law is. That's where all this shit goes down. And I remember years ago, before I even knew this stuff, I looked at those probate doors and I was like, every time I'm in court for a traffic ticket or something, those doors are always closed. And they deal with kids and dead people. What the fuck? You know? So it made perfect sense. Oh, that's where everything's gone.
Right.
So I looked up and researched the judges in Maryland. And in Maryland, there's 3 judges in every county that are probate judges. 2 of them are lay judges, which means they have no license or a bar card. They're not attorneys. They've never been to law school. Actually, the guy that I sent mine to owned an HVAC company. He was just a contractor, but he was also a probate judge.
Really?
Yeah.
Shit.
Yep. So I was like,
Renter judge?
Yeah, I don't know. But what that told me was that dude's private. That dude's private. He's the one that's going to get my shit. Why? Because he doesn't know what the fuck's going on. So he's going to have to take that to the attorney or the attorney, right? Because the head judge, well, no, actually he was the head judge, but there's one judge out of the 3 that is a bar card holder, right? Ex-attorney, whatever. Mm-hmm. So I knew that he's going to take this. He's going to go to them. They're going to go higher because they're not going to know what the fuck it is. And that's how it unfolded. So I just noticed him privately. And I kept noticing over and over with different parts of this process until I was ready to issue that full package. And the interesting thing is I never, ever got a response from this guy. Never, or from the state. Not that you know how they do. You send them shit, they don't respond.
Yeah.
But here's the interesting part. I gave them $5 million. I allowed them to create $5 million because I gave them a $5 million bill of exchange. Why? Because the state commercially can only book $5 million at a time. If you give them an instrument more than $5 million, they can't book it. It's outside of their charter. They can't do it. So only $5 million. You don't go above $5 million. So I didn't know what the charges were, you know, on the back. I don't know. I don't see their little secret code book of what the actual, you know, fines are. So I figured, well, $5 million should cover it, which it did. Covered mine and his, right? My co-defendant. So I said, well, shit, I'd like a balance on that. I'd like the trust to call for a full accounting on that particular instrument. I don't care about the cesta key and I don't want a full accounting on that. I want a full accounting on my $5 million note on my negotiable instrument. So I wrote them, you know, same judge. I said, you know, in all fairness, we'd like a balance on that. And while you're at it, whatever the balance is, go ahead and take care of these bills. All right. And sent them all my bills, these accounts. You go ahead and take care of them.
Like a light bills and stuff?
Yeah, everything. Car bill. I was like, fuck it. I'm just going to throw it at them, see what happens. So that's the only time I got a response. The only time. And it wasn't from the judge. It was from the Attorney General of Maryland. And she said, I'm sorry, but, you know, this is what she said. Basically, in so many words, she said it's outside our jurisdiction. And I was like, oh, that's interesting. It made sense because I was now in Florida at this time. And I was like, wait a minute. It is out of their jurisdiction because I am now, since they look at me and they go, oh, well, this is coming from Florida. You're Florida. You have to deal with a Florida treasury or something along, you know, so you have to deal with the jurisdiction that you're in. Number one, you're not in the state of, you know, right. And number two, you're in another state to begin with. So we can't deal with our treasury, you know. In other words, we just don't have jurisdiction in this matter. But she didn't say it was illegal. She didn't say anything about anything else. She just said we don't have jurisdiction.
Should have tried to cash in too.
What's that?
Get a couple bags of FRNs while you're at it, you know?
Yeah, well, you can't do that because you'll go straight to jail. Pass go and go to jail.
Well, let's clarify that point real quick, Robert. Because
I was going to.
A lot of people really do try to, figure out ways to cash out. And I know that there's obvious reasons why they would want to figure out how to create free money in FRNs, that are spendable in this society.
Right.
But am I hearing you say that you're speaking in this?
I'm going to Disneyland.
Hold on. You're talking strictly in discharge, right?
Strictly discharge and set off. You cannot get cash. If you get cash, you're going to jail. And they will deliberately cut you a check and wait for you to cash it so they can do that to you. Yeah.
I don't doubt it.
Get the check and get it and draw it through an. Well, it wouldn't matter, would it?
Well, let's look at this another way. But you got to look at this another way. What is a debtor in trust law? Okay. What is a lien in trust law? It's an asset. So a debtor is an asset. So now if the government becomes my debtor because I issued an instrument to them, right? And I lien the instrument, not them, but the instrument which is held by them. So essentially, yes, the lien is on the agreement that we have is the lien. Okay. Now I have an asset. So I don't give a shit what they do. I should be
currency because it's saleable.
I should be able to, well, it's an asset, right? So you can get asset-backed loans. I should be able to go to a bank and go, look, I got this asset here. It's worth $5 million. So here's what I'm going to do for you. I'm going to create a promissory note for you that you can take, go ahead and take 20%. You give me credit on account. I don't want cash. I want credit on account for the 80%. You guys take 20 and go ahead and loan that out 9 times the amount. And y'all just made a ton of money for nothing. And I got my credit on account that I don't have to pay back.
Sure.
How's that?
Theoretically.
Debt is money because it can be sold, right?
Well, it's not even that it's money. It's all we have is debt. So we have to deal in this discharge and how we create it so we can continue to create it. Yeah. So have I done that yet? No. But I mean, in theory, like you said, Greg, that works, man.
Sure.
But we got to find a banker that's willing to play. So,
well, they're all willing to play. They're all crooks. They're all greedy.
Yeah, but they're not willing to play with us. They're not willing to play with the commodities. They're willing to use us as commodities, but not do business with us.
Right. Can't work.
Although, I may have some insight into that coming up here shortly. But again, it's for a later conversation. No
doubt.
So now,
on the land, man. Right?
Oh yeah, fuck, absolutely. There's nobody on this earth more powerful than me.
Well, I think. Well, let's stick with that for a moment and just kind of touch upon what we were just talking about, which is everything is debt based. We know that because there's no value backing the physical FRNs. We know that everything is being put into existence through them creating bonds of some sort based upon our future labor that will contribute to their system. Is that your understanding? That's been my understanding. Like you were saying, I guess earlier, some people say they create a trust. You're saying they create an instrument, which then they create trusts off of. But no matter what, it's based upon your physical future labor. If you don't exist, that bond never can exist.
Well, yeah. So here's the thing. When a piece of property or a commodity is held in a warehouse, and there's a duty to be paid on that piece of property, a tax. Okay, that's called held in bond. Now, it doesn't mean there's a bond created, but it's held in bond. Now, that means that yes, you can create bonds and instruments off of that. See, so yes, without you being the root, none of this can happen. So all we're doing is reversing the roles and saying, no, I'm not the commodity. I am the giver of life. I am the creator. I am the creditor, you know. And now I've established that firmly on the record. But here's what I did, though. I took a birth certificate, a warehouse receipt, and I sent it back to them under a new bailment agreement. Here's the new terms of the agreement, Jeff Sessions. You've got 3 days because that's all you need under contract law. You got 3 days to respond.
Right.
Now, I'm giving you a negotiable warehouse receipt, okay? You can use it for this, and this, but you can't use it for this, and this, which is war, poisoning my food, poisoning my water. You can't use it for any of that. You have to use it for this. And it's got a value on it of $33 billion. Okay. Why? Because I said so. So because it's negotiable instrument, it's my life value. So actually I didn't do this. The trust did. Wink, wink. So the trust sent them this bailment agreement and gave them a warehouse receipt, a blank one, certificate. Now you guys are the bailee once again, just like you've always been, except we got a new arrangement here.
Right.
So we'll see how that goes. They tried to block my UCC1 actually in DC. It just disappeared.
Oh yeah.
It just magically disappeared.
Hey, hey, hold on before you guys. I just posted in the chat a new chat room number. See it? 602-965-501.
I need to chat up.
Well, I'm just thinking we you still there? I think it's going to stop recording here in a second because I don't think I have the pro version apparently.
Oh, no.
Yeah.
I don't have the chat.
Well,
we didn't lose you, did we, Robert Michael?
Nope. I'm just checking some stuff coming in, waiting.
Hey, but in fact, if you do, I know you got a lot going on, Robert. We could just have this as part one and then just continue again when you get back from your trips and stuff.
Yeah, we could do that, man. If there's anything else you want to go over real quick.
I mean, mainly I want to. For me, I appreciate where you're coming from. I appreciate your vibe. I appreciate your honesty, and I appreciate what people say about you, and just overall. So I wanted to give people the opportunity to hear your perspective and what you're offering from Truth and Trust. I know that me and David and myself, we've spoke about trust on many different occasions. You and I, as well as David, you all know that I love Carlton Weiss's material.